We're going to turn now to a major ruling yesterday from the Supreme Court, which made it more difficult for the big lie to repeat itself in 2024. The case, Moore versus Harper, based out of North Carolina, centered on a radical theory known as the independent state legislature theory. It would have given state legislatures virtually unchecked power over federal elections based on an extreme interpretation of the Constitution's election clause. In a 6-3 ruling, the Supreme Court rejected that anti-democratic theory, with Chief Justice John Roberts and Justices Brett Kavanaugh and Amy Coney Barrett siding with the liberals. In his opinion, the Chief Justice writes, the Elections Clause does not insulate state legislatures from the ordinary exercise of state judicial review, adding that the legislatures, the framers recognized, are the mere creatures of the state constitutions and cannot be greater than their creators. John Eastman, a legal advisor to Donald Trump, embraced this fringe theory as a way to overturn the 2020 election, arguing that then Vice President Mike Pence had the power to refuse to certify the results. In an email exchange with NBC News, Eastman claimed the ruling would prevent legislatures from addressing illegality and fraud in a timely manner. When asked if the ruling invalidates the arguments he made in 2020, Eastman wrote, quote, "No, but it will be murkier than it was previously." Let's bring in the attorney who won that Supreme Court case, Neil Katyal. He's also an MSNBC legal analyst. Neil, I'd love to hear what you think about Eastman's comments on this, and also what were the main considerations before the justices that made this 6-3 rather than unanimous.
Thank you. Pleasure to be with you. It seems to me, I guess, John Eastman can read Supreme Court decisions about as well as he can read the Constitution. I don't think it's worth talking about his views, quite honestly. But basically, look, here's what happened in this decision. There was a legal theory that Donald Trump peddled, that John Eastman peddled, other Republicans peddled in 2020, that state legislatures can do whatever they want. That's because, remember, there were about 60 court cases in the 2020 election. Trump lost them all. They were all basically in state courts. And so this Republican theory that was now advanced again before the U.S. Supreme Court is the idea that the state legislature can do anything it wants, from redistricting to even throwing out the popular vote and appointing a fake slate of electors. And they can do so without the state courts, without the state constitutions having any role in this whatsoever. It's just raw political power. And that's what the Supreme Court resoundingly rejected yesterday in the Chief Justice's opinion, an opinion that was notably joined by two Trump appointees, Brett Kavanaugh and Amy Coney Barrett.
You know, Neil, congratulations on this victory. And of course, there were some analysts concerned that it was possible it would go the other way. But let me ask you this. Is it encouraging that it was a supermajority, that it was a 6-3 decision? Or is it discouraging because that means 3 members of the Supreme Court were willing to embrace a doctrine that has been seen as quite extreme and fringe in the past?
I think it's quite encouraging. I mean, it's a signal to me that the Supreme Court, with a solid 6-justice majority behind it, you only need 5, that these 6 are going to resist attempts by state legislatures to mess with the integrity of future elections, including the 2024 election. And you're absolutely right that many people thought we wouldn't be able to win this case. Indeed, all of our allies, all of the other plaintiffs in the case, tried to go to the Supreme Court and tell them not to decide this case after it was argued. And they wanted to try and get rid of the case. And those arguments were so wrong and so misguided, and they stand as a powerful lesson that if you carefully study the United States Supreme Court's decisions, litigants can win cases that stand up for our democracy. And that's what happened.
Neil, congratulations on winning this case. If we can bring it down to a ground level for people, because it is so significant, what it might have looked like in 2024 and beyond if you had lost this case at the Supreme Court, what would elections look like in places like North Carolina?
Yeah, super dangerous and scary. So it would mean, first of all, state legislatures can write all of the maps for who votes, how to district, and they could, exclude people or, empower certain people. Like this election map that this case had, it came from North Carolina. It's an evenly divided state, so there would have been 7 Republicans and 7 Democrats if it were done normally. But the way the Republican state legislature did it, they gerrymandered it, so it would have had 10 or 11 Republican seats and only 3 Democratic ones. And that's just on districting. It could be on anything. A state legislature could say, for example, no one can absentee vote, period, no one at all. Or they could change the polling places in minority communities the day before the election, or they could have done any number of shenanigans. Is limited only by their ingenuity, and they would be able to do it, and the courts would have no role whatsoever in policing that. The state legislatures could do anything they want. That's fundamentally un-American. That's what I said to the Supreme Court. I said, go back, start at the founding. Justices, you claim to care about the history of the Constitution, the history of this country. Go back and look. It's as clear as day.